That is the defendant's own words. Those were played earlier on in the court today. That was his police interrogation tape. Remember, on his first statement, he denied having anything to do with the death of young Kente. Really? Let's talk a little bit more about it with law and crime trial analyst Ken Belkin. Ken, we don't have a ton of time to talk. It's great to see you, first of all.
Great to see you,
so in his first statement, he goes, look, I had nothing to do with it. In his second statement, he goes, okay, you know what? Yeah, I did push his head into the water for 30 to 45 seconds, but it seemed to be an accident. What's going on here?
Classic case of your story changing, which leads me to believe maybe the first statement wasn't quite as accurate as he would like us to believe.
But the defense is saying, and this is the weird part, they're saying he's responsible for the death, but he's not guilty of murder. How does that happen?
Well, they're going to say he didn't intend to kill him, you know, he had no intent to seriously injure or take life. He was merely disciplining his child. Last time I checked, you know, waterboarding was not an acceptable form of corporal punishment.
And what about the idea that you're going to die tonight? That's a, he says it was a joke, or should jurors take it as a sign that he was really going to kill him?
Well, it's not a good look. It is definitely a statement that is going to be used against him, and it carries some pretty heavy weight. But people do use that expression colloquially.
They really shouldn't. It's not a good statement to make, and especially in this case. Ken, stand by. I will be signing off. Bob Bianchi will be signing in, and he will guide you through the next chapter of this case. We believe the defense will start their case later on in the afternoon, and there is the potential that Leon Williams, the defendant himself, may take the stand. So we'll take a quick break. We'll be right back. Stay tuned.
Welcome back to the Law and Crime Network. It's great to be back with you guys. It's been a week or two since I've been on. I'll be hosting for the next couple hours. I got Ken Belkin here with me. But right now, we're going at a lunch break with the Georgia versus Leon Williams case. Really a terrible case here. Another tragic failure, you know, in the system. But we're on lunch break with this, Ken, but we also got some other great stuff. You got to love the cases that the Law and Crime Network pulls out, because it's always these really dramatically great cases that are great opportunities for us to speak. And that's Florida versus Cully. And we actually have a preview here of this case. It's going to be coming up shortly. And so we'll go to the preview and we'll come back on the other end and we'll talk about these great cases. Holy cow, Ken. I mean, you know, we started out many years ago when you see the iterations of defenses. First, it was the Twinkie defense. You remember that, that old bad boy.
San Francisco, baby.
Yeah, now, and this isn't the first Ambien case that's come across the desk here. So what are you thinking about the use of these kind of defenses and with the use of Ambien in particular? Because it's not the first time we've seen it.
Well, I don't think Ambien's going to be advertising anytime soon on this network. But look, I mean, the defense centers around the theory of involuntary intoxication. Presumably, he was not dosed unbeknownst to him with this Ambien. He ingested it voluntarily. These drugs have psychotropic effects that are well known about. The warning is on the bottle. How can he say it was involuntary intoxication? It seems like these defense attorneys might need to go back to law school.
Yeah, you know, I always knew in law school that, or was told, and from my experience as a practitioner, involuntary intoxication is only a defense if a substance is introduced into you that you're unaware of. For example, somebody slip something into your drink. Yeah. When you're voluntarily taking a substance, you usually can't avail yourself of the involuntary intoxication.
It's not involuntary. You know, you're taking it. You're choosing to ingest it. You're choosing to live with the side effects. Now, that being said, I'm not quite sure the side effects of Ambien are what led Mr. Colley to his current predicament. Because, look, this guy was in court that day fighting a case for an order of protection his wife had against him. Very strong motive. And these things get very heated. As you know, you've been in these courthouses with order of protection cases. The parties are extremely emotional, extremely irrational, and in many cases belligerent.
Right, and I think that's a great point. It's what was leading up to this, and in fact, other witnesses saying he was so agitated at that court hearing that it's more likely that the jury may believe it was the agitation over the court hearing as opposed to taking Ambien. Anyway, listen, we're going to get the more great analysis with Ken, but we want to throw to the top crime stories. You know I love this segment, and we're going to come back on the other end, maybe talk about that, talk about one of these cases, Ken. We have it all here on the Law and Crime Network. We'll see you on the other side. Well, Ken, I already have too many things I want to talk about just based upon that. And I want to just throw back to the previous conversation a little bit about involuntary intoxication now. And I like to give our viewers like a little data points that sometimes are unusual for them and they don't get.
Yeah, yeah.
But what I have seen with greater and greater frequency now, Ken, is also in the DUI space. I recently did a blog on my social media platforms about this, where even if you're taking prescription medication lawfully prescribed by a doctor, and if it has any kind of warning on it that says, you know, be careful when you operate machinery before you drive a vehicle, if you have an event where you get pulled over and indicate to the police that you're under that and they believe you're under the influence of that, you could be charged with DUI. Many people are surprised about this.
Well, what's more, while you're stopped, at least in the state of New York, they could call an ambulance and have you blood tested on the side of the road, and if you refuse that test, you know, you're automatically, your license is suspended and you're charged with driving under the influence.
Yeah, I mean, back in the day, I mean, this just shows you how the laws are changing so much. Back in the day, if you showed that you had a lawful prescription for something and you were taking it and you had the proper dosing, you would never be charged with being under the influence.
Yeah.
But we're seeing that happening more and more. And what I have one right now where I'm just curious. I think the person actually just had a medical event while they were driving, and it had nothing to do with the medication that they had been on for 15 years.
Well,
but nevertheless,
that's a good defense, you know, right there. But, you know, these cases are complicated. And look, it's no secret these cases are a huge revenue generator for the municipality. Everyone makes money on these cases, including, you know, unfortunately, us guys slugging it out in the courthouse.
Yeah, and you know what? Listen, I mean, these are like, they're mainly traffic tickets in most places, but they are the mother of all traffic tickets because there are substantial consequences to a conviction.
Oh, yeah.
But anyway, going back to one of the crime stories, another thing that's changed over the years, teachers and students having sex with one another. And so I've had a number of those cases in my career, and I actually remember a time where if it was basically a male student and a female teacher, good luck on getting it charged. Today, completely different environment.
Yeah, I mean, I don't know where these teachers were when I was in high school, because I certainly
that was
have
Ken
luck
Belkin
like
that said that, not Bob Bianchi. But go ahead.
You know, and I even had hair back then. But, you know, look, it didn't work out that way for me. I think the culture and the landscape has shifted, and we want to treat sexual assaults equally, you know, regardless of gender.
Yeah, sure. I mean, listen, the power relationship is usually where the statutes are saying you're in the custody and care of the state. You're required to get an education. And these people basically have to treat you as a parent would. That's the underlying basis as to why this is inappropriate. But I actually had a case with a male student, and I was very interested in the psychiatric testimony when they indicated how bad this is for boys more so than girls, because it's harder for the boy, kind of for the reasons you were laughing about, to understand that it's actually a crime and was a bad thing, not a good thing. So it takes them a longer time to get to that space of healing.
Yeah, and forget about the male-female dichotomy of it all. You know, as you said, these are teachers. These are these are agents of the state, essentially. These are government actors abusing their role to take advantage of young male students. It's potentially a huge civil rights violation as well.
Yeah, actually, funny you should say that. I filed it under a civil rights complaint when I was a plaintiff's lawyer. But listen, we are on break right now for Georgia versus Leon Williams. It's a sad but fascinating case. We'll have a lot to talk about. We just got done with our crime stories there. And we, you know, Ken, listen, on the Law and Crime Network, we are just killing it. You're a trial analyst here. You gotta love every opportunity you have to be on this show. And we are going to go to a break. And after, on the other end of that break, we're going to talk about a little more on some of the crime stories and some of these fascinating cases. We'll be right back. Welcome back. So we are on break right now, Ken, with the Georgia versus Leon Williams case. This is such a sad and tragic case. I was actually talking to one of the producers prior to coming on here. You have a 10-year-old boy who is dead. Poor kid was in foster care for 7 years of his life. And from all accounts, at a minimum, irrespective of the charges in this case, which are malice murder, felony murder, child cruelty, and 2 counts of aggravated assault, you see a picture of the little boy there. By all accounts, the father was a little heavy-handed, to say the least, was burning the boy's feet, holding him underwater, as you were indicated earlier with Jesse, akin to waterboarding, and accused of making some really bad statements like, I'm going to kill you, whether he meant it or he didn't mean it. This kid was really under a lot of emotional and physical pressure. Yeah,
this is a horrible set of facts, and, you know, this guy's going down. He might not go down for the top count. They might have some problems proving intent. The jury may not want to ascribe intent to him, but certainly, you know, it looks to me like he is beyond a reasonable doubt responsible for this child's death.
Right, and you know, we always get back to that old ace card for the prosecution, the felony murder charge, which I love to talk about so much, because you're right. They may find that it was just a little overreaction, he didn't mean to kill, there wasn't an attempt, but during the commission of a predicate felony, if there's a death, it's basically as if you murdered him as far as the sentencing is concerned.
Oh yeah, for sure. And look, they've got all this evidence of, you know, the kid was being abused, inconsistent statements. He would try to explain away bruises on him. You know, there's a lot of circumstantial evidence here.
Right. Well, listen, we're going to even get into a little bit about Child Protective Services and the failure with respect to that and the difficulty with the job they have. But before we do that, let's go to this police interrogation and hear from the mouth of the defendant himself, because as one of my mentors used to say, juries love to convict for the prosecution side based on the very words that come out of the defendant's mouth. So let's take a look at that interrogation. So that is an actual interview that you're listening to being played inside the courtroom in the Leon Williams case. They're on break, so we're listening to that testimony, and this is his explanation to the police as to what occurred. I'm with Ken Belkin. He's a trial analyst here at the Law and Crime Network. And Ken, just one of the first things that hit me viscerally is the sound of the voice of the defendant when he's speaking to them. He seems disturbed, upset, agitated. What were your thoughts?
Yeah, I mean, well, presumably this guy's about to be charged with the murder of his 10-year-old foster son, so being agitated is probably the least of it, you know. And look, it's probably traumatic for him, too. I don't think that this guy intended to murder the boy. I just think he took his disciplining methods a little bit too far this time.
Yeah, do you think we often talk about jury nullification, and as a defense lawyer, certainly in a case like this, you only want to try to one juror, right? Maybe get a hung jury. And you have to prove that predicate offense, which is the child abuse charge. Do you think that this is going to have an emotional impact on at least one juror to say, look, this was just something that really went sideways. It's an unfortunate thing. He didn't mean it to happen. I'm not convicting.
I don't think any jury is having sympathy for this guy. You know, I've tried cases where a jury was deadlocked for 3 or 4 days because of one person, but it's a different scenario. This is the death of a 10-year-old kid. There's a deep sense within each of us, when especially a child's life is ended so prematurely, that we want justice.
Yeah, I agree with that. There's a lot of compelling factors, including the fact there was a lot of contact with Child Protective Services. We're going to go back to listen to a little bit more of that in-courtroom interview of the defendant, and we're going to come back on the other side and talk about it. Ken, thank you. This is Georgia versus Leon Williams. The case right now is on break, and we're listening to the in-court testimony, if you will, which is actually playing the statement that the defendant gave in the case. And I'm here with Ken Belkin, a trial analyst here at the Law and Crime Network. And we were talking before, I mean, the statements, first of all, you should always remain silent, right? That's always a good thing.
Not helpful. Not helpful.
You don't see it, right? You think he's hurting himself with what he's saying?
Well,
here?
look, this guy is admitted to beating the kid with a belt, to pouring hot water on his feet, and to employing a method of discipline that included holding the child underwater 30 to 45 seconds at a shot. I mean, the child died from drowning. Yeah. Not a far stretch of the imagination.
Yeah, and these statements that are made that I'm going to beat him and I'm going to kill him and, you know, you're going to die tonight certainly are going to be taken in conjunction. And Child Protective Services, having been there and having walked away from the scenario, I mean, you've been involved in these kind of cases. I know they got a tough job, but and usually the spotlight only comes on when something bad like this happens.
It's funny, because in my experience with Child Protective Services, a lot of times they drop the ball on the serious cases, but less serious cases where maybe the allegations aren't true, they go so hard. You know, it's so subjective, and it depends on the individual caseworker, really.
You know, Ken, we literally, the producer I was talking to just before we went on, I said, you know, it's amazing sometimes that you see them take children away, and you're saying to yourself, for that? It doesn't make any sense, yet something like this gets past it. And it's because you're right, individuals are all different in how they're assessing their caseloads.
Yeah, we all bring our unique prejudices and experiences to every situation. And for whatever reason, you know, this caseworker didn't see the need to act as if there was an imminent danger to the child.
Yeah, and there were actually, at one point I thought it was interesting because the worker said in the report, oh, I wasn't injured by my father. He wasn't even here. And there wasn't even a follow-up. You're 10 years old and you're alone in your house.
In your house.
Yeah, and 3 of those workers, so you know, they were removed from their responsibilities. So we're in Georgia versus Leon Williams. It's a fascinating case. And we are going to be moving into a break, and then we actually have, after that break, some live statements from people that are actually inside the courtroom. They're going to be speaking to us about what the feel is going on in there. So we'll be back on the other end of this break. Hey, welcome back. We are on break right now in the Georgia versus Leon Williams case. This is where the 10-year-old boy that was in foster care for so many years was essentially drowned to death. I got Ken Belkin with me, trial analyst, and we just listened to Josh's report. He was literally inside that courtroom. I'm just going to throw it to you. What did you think about what Josh said and what it means for the defendant?
From defense attorney standpoint, not a good look that jurors are getting up crying, asking for a break. This shows to me that sympathy is not with this defendant, it's with the victim. Yeah, for sure. And I thought it was also compelling when he talked about how the caseworker was crying from the witness stand and wanted to actually adopt the child, you know, herself, but wasn't able to because of the rules, obviously, of their state. I think that's going to be very emotional in terms of that this was not such a bad boy, or if you will, because there's going to be a little bit of that. Like, did the kid drive him to this? You think that that's going to play at all favorably? But by the way, big surprise. Kids are a huge pain in the ass. They drive their parents absolutely crazy. Doesn't mean you hold the kid underwater and drown him to death. It's not acceptable. Holding a child underwater for any period of time is totally unacceptable parenting.
Right. You know that usually victim impact testimony, we would call it, is usually not admissible in a guilt phase, and that is essentially
it's a sentencing issue.
It's
really.
Usually a sentencing issue, right? But through that witness, I think the prosecution smartly was able to get some very positive victim, that is the 10-year-old boy, testimony out there. And obviously, like you said before, it's just compelling in and of itself that it's a 10-year-old boy. But I think it was a pretty good move by the prosecution to do that.
Yeah, there's really nothing that almost nothing I can imagine that would warrant the taking of a 10-year-old boy's life.
Okay, I'm going to flip it to you in 15 seconds or less. I got to do it to you. I'm going to put you on the spot, Ken Belkin. You're the trial analyst at the Law and Crime Network, so you can do this. You're the defense lawyer. What are you going to do for this guy? And I'm giving you 15 seconds because I know there's not a lot to say.
Negotiate a plea that's favorable, that maybe gets him some treatment and help and results in a minimal period of incarceration. That's a best case scenario here. Obviously, that wasn't something that was able to be worked out, or maybe anything offered was, rejected by the defendant himself. But taking the chance and rolling the dice at trial, it's not going to be a good result. You've got a 10-year-old boy that's dead.
And I always would love to know, like, what were the plea negotiations before it broke down and it had to go to trial? Because those are very important considerations to any case, because is the defendant really taking a big risk here? They may have offered numbers so big that the defense lawyer said,
they probably offered him 20-year minimum, and he said, the hell with that. I'm risking life without parole. Might as well go for it.
Yeah, very, very good, insightful point that we should talk about a little bit more. But listen, we're dealing right now, we're on break, and we're listening to courtroom testimony where that interview of the detective that took the statement is being played. We're going to listen to a little bit more, and we found out from Josh, and again, it's great to have somebody in there, no questions for the detective on the case. A little odd before we get to that interview. No, not a question.
Yeah, first of all, that's just lazy defense attorney work. You got to get up there and you got to ask some questions about the arrest, about some of the fact that, well, you weren't there at the time, right, detective? You didn't actually witness anything, right, detective? You've got to get it out there that this detective is not really a witness to any of the allegations. He's only a witness to the arrest and what this defendant said upon being taken into custody.
Yeah, and there's two schools of thought with that. Sometimes if you stand well, stand still, or you don't want to make it any worse, and this isn't really an essential witness to the defense, you could just kind of walk away. Or I think most lawyers inclined to
it gives
ask
out an image that you're sending up a white flag. And as a trial attorney, you don't give up. You never give up.
Yeah. Okay, so let's go back into the courtroom and listen a little bit more of the statement that the defendant gave to this detective, and we'll come back on the other end to discuss it with Ken. We had an opportunity earlier, I'm here with Ken Belkin, who's a trial analyst at the Law and Crime Network, to listen to one of the reporters who was actually inside of that courtroom and was noting that, and we had noted this before, that there were a number of lies that were being made, and almost like an attempt to push it off on the kid as being responsible for it. And then all of a sudden this riveting testimony, apparently to a point where you had a juror crying and then an actual child protection service person on the witness stand crying. I mean, we were talking about, like we were saying before off camera, what is there really to talk about in this case?
Look,
right?
if you're a defense attorney and your brilliant strategy is to try and shift the blame to the 10-year-old boy who was murdered, this is not a winning strategy. You know, a lot of people dropped the ball here, and I don't think this 10-year-old boy should be getting any victim blaming of any sort. You know, if anything, you know, blame goes to the father, certainly. Blame also goes to those caseworkers in the Division of Family Children's Services who within a month were called to this house twice. And, you know, the kid had bruises, and his story as to how he got these bruises changed. His story was inconsistent. A competent caseworker should have picked up on the fact that the story had changed and taken action, because a changing story indicates that, you know, the kid's not being truthful and that maybe there might be something untoward going on in that household.
Yeah, and some of this was at certain points the child was indicating that, oh, I bumped my head, or basically saying he's accident prone, my father doesn't hit me, and you just have this like emotional feel to this, that this kid was in foster care for all these years. I can imagine sitting there listening to this and would do anything not to be back into that system again, even if it meant that there was going to be some level of abuse that they had to sustain. I mean, that's just the feel that I get of it. It's such a gut-wrenching thing, Ken.
And children are intimidated by adults. You know, they're taught adults are the responsible ones, the wise ones. They know better than you. You know, adults are just as flawed as many children, and these caseworkers should have picked up on this.
Yeah, and we often talked about the idea before that you have caseworkers that are removing children from the parents' homes that are
for very little.
For very little.
Very little.
Yeah, and you know what? It doesn't seem like the states can just get their arms around this. It happens everywhere. They can revamp the system. You can fire people, but it just seems to be the same thing over and over again. What is it, Ken?
I don't know. I like to chalk it up to bureaucratic inefficiency. I'm a card-carrying liberal, but at a certain point, I got to recognize private industry does things better and more efficiently. Maybe this stuff should be privatized to an extent.
Yeah, you don't know if it comes down to the training module or lack of supervision. I found that as the prosecutor, that when we had some disparate criminal justice results that were going on, it was really the result of the fact that the people at the head, the top, the prosecutor, wasn't watching the store to make sure that there was consistency and proper training. At least that was my experience.
Yeah, well, they definitely need to revamp their training manuals.
Yeah, this is really hopefully a case, and this is why I love what the Case of the Law and Crime Network brings on the show, because it puts a spotlight, and there certainly should be one on this, that hopefully somewhere down the road, somebody is going to do something from a government standpoint to make sure we get the right people, temperamentally fit people, properly trained people in there, so tragic deaths of 10 years old people like this does not occur. We'll be back at the other end of this break. Welcome back to the Law and Crime Network. It's a Dan Abrams production, gavel-to-gavel coverage we have on these cases. Right now we have Ken Belkin with us, trial analyst at the Law and Crime Network. We're doing Georgia versus Leon Williams, a case of great public significance. I love the cases that this network brings out and the opportunity that people like us have that have experience in this background to make a difference. And we really appreciate our viewers that are out there that are listening to this, because we can make substantial social change when we promo cases like this to make sure 10-year-old boys don't have their feet burned, and girls for that matter, 10-year-olds don't have their feet burned, are tortured, or held underwater and waterboarded. And that's what this case is about, not going good for the defense. But before we go back to that case, and I have more opportunity to talk to Ken about it, we have some of the great top crime stories, and Ken made a specific request that we speak about one of those stories on the other end. And of course, I'm going to accommodate Ken, because Ken's the man. Welcome back. So I have a special request from Ken to talk about the top crime stories, and you want to talk about the NFL player Brandon Browner. I hate to say, I'm not like a follower. I don't know like the stats of a player or whatever. What do you know about this guy?
All I know is what he's charged with and what he's accused of. Other than that, I've never heard of him before. But that's, I don't follow sports. But, you know, this is an incredible case. I wonder if he perhaps is being overcharged given his fame.
Well, you know, we were recently having a discussion about this. It's been my experience that people who are famous sometimes can bear more weight because the public eye, and you have prosecutors and police that want to.
It's a notch on their belt, you know, to bring someone famous down. We all like to see someone who's high up on the totem pole get knocked down a peg or two.
Yeah, well, having been a prosecutor for many years as an assistant prosecutor, head prosecutor, I never, and I don't think any of my colleagues that I can recall were actually looking to put a notch on their belt so much as they were concerned about the idea that if they didn't go heavy against a popular or famous person, they would be perceived as giving them a break, and that people that weren't popular or famous were bearing the brunt of the criminal justice system. I saw more of that at play.
Well, I'll tell you that Mr. Browner, I'm not perceiving him getting a break here. Yeah. That attempted murder charge is really serious. I mean, she already had an order of protection against this guy. This is a tough case.
Yeah, and you got to wonder in the context of domestic violence. I mean, you get these restraining orders, and these guys, I mean, I don't understand it. They not only don't follow it, and we see that all the time, but they just go in there and do something as crazy as what's alleged here, stealing a $20,000 watch. It probably doesn't even make a difference to them, a $20,000 watch. This cycle of domestic abuse is really frightening. And I always used to say, Ken, to my staff as a prosecutor, be careful with these domestic violence cases, because today's domestic violence is tomorrow's murder case. And I found that to be true in many instances.
Oh, absolutely. And you know, this guy, clearly he had a history of domestic violence, or there wouldn't have been an order of protection in the first place, and he's violated that order. You see it constantly. These people, for some men, women are more addictive than drugs. They cannot keep themselves away from this person, even if a court order has been issued compelling that they do so.
Right. Now, listen, we don't know all the facts, but certainly the charges are significant. Apparently, this activity was occurring in front of 2 minors as well. And you know that we're going to be all over this at the Law and Crime Network. But right now, we're covering a not famous person, but a person that has done an absolutely horrible thing. Law and Crime Network is bringing attention to the Leon Williams case, where a 10-year-old child that was adopted by Mr. Williams, was in foster care for 7 years, is now being charged with malice, murder, felony murder, child cruelty, and 2 counts of aggravated assault. We've had compelling testimony so far, Ken, but what we're going to listen to right now, they're on break, but we're going to listen to a clip that was played earlier today of David Walker, who's from the DeKalb Fire and Rescue, walking into the scene. I was an EMT for many years and walked into a lot of scenes like this, and it's you know, while your natural reaction as a first responder is to assist and render aid, afterwards sometimes you pull out of the scene and you just, when you decompress a little bit, you're like, yikes.
It dawns on you what you've seen.
Yeah, really horrible. So let's listen to that testimony and we'll talk about it on the other end. Welcome back to the Law and Crime Network. Listen, we're listening to testimony of first responders now. Always compelling information. And we're in the Leon Williams case. They're on break right now. And Ken, I mean, this is always dramatic testimony for a prosecutor, because it's just dramatic when you have people who have no horse in the race. They're independent witnesses. They're just responding to a crime scene, which turns out to be a crime scene, to rescue a 10-year-old boy. And as I was saying before, nothing worse as an EMT or as a first responder than when you're trying to save the life of a child.
Yeah, absolutely. I mean, the cumulative effect of all this testimony, and really it's circumstantial testimony. You know, none of these people actually witnessed the commission of a crime at all. But the cumulative effect of it is going to tug on the heartstrings of these jurors. And I'm going to make a bold prediction. I don't even think they're going to deliberate for a full day.
You know, we used to wonder when we were trying cases as prosecutors, like, how long will it be until the jury comes back with a knock on the door? I actually remember a funny story where one guy was debating me. My jury will come back faster than yours, and my jury came back pretty quick with a guilty verdict, and his went out for 8 or 9 hours, and when it came back, it was a not guilty. So we had a lot of fun with him.
Usually the longer they deliberate, the better for the defense attorney.
Yeah.
You know, but not always.
Yeah. So I mean, we also have other testimony of other first responders. One of the responders was a Jennifer Duggan. She's a paramedic, so she would be more directly, a paramedic is going to be higher than an EMT or a cop in terms of the actual treatment.
Yeah.
And when they respond to the scene, they're doing advanced life support. So let's listen to a little of that testimony and come back on the other end and discuss it. Welcome back. That is Jennifer Duggan. She's a paramedic that you're listening to in the Leon Williams case. She was treating the young boy, 10-year-old boy, who died at the hands of his foster father, actually his adopted father. And this poor kid had been for years in the foster care system. There was contacts with Child Protective Services. She's actually testifying about the night and her efforts and their efforts to save the boy. Two things that I found compelling that, again, just adding on to the defendants in a whole whopping amount of problems here is that he's lying even to the paramedics who were trying to do medical treatment, saying that he left them, he went to change, he came back, and that was the condition. So that certainly isn't good, Ken.
Not good. I mean, the inconsistent statements that this guy has given pervades the whole case. There's no way to get around it. I mean, I was just saying to you during the break, like, what is the defense attorney going to do when the prosecution rests their case? They can't put this guy on the stand. There's enough inconsistent statements that he's given out there that they're just going to nail him on cross-examination. Well, you said this, but then you changed your story and said this, correct? And then you even later changed your story and said this. And all three of these things are different versions.
I'll even give you something I think is even worse. In my mind, I'm sure it is yours too. 4 times he's saying he guesses they're not going to give him another kid. That's what he's concerned about, while his other son is now potentially dying. That's his concern. Is that not bizarre? And will that not create hatred emotionally in the jurors' hearts, even though they're not supposed to have those emotions?
I mean, a very, very concerned parent that he is. He should have been more concerned with his disciplining methods. This guy's probably more concerned with the stipend he was getting from the state.
Exactly. But listen, we're going to roll to a break, and when we get back, we got a lot more law and crime for you. Thank you, viewers, always for watching. We'll be back. Welcome back to the Law and Crime Network. And listen, we've got a lot going on here. We're on break with the Leon Williams case. And we also have this new case that we're teeing up. We want you to see a little bit of a preview. And I'm going to talk to Ken on the other end. It's James Colley. It's murder. It's like I like to say all the time, murder, mayhem, and you got it all. We're on the front row of human nature here.
This is the nature of the business. That and the murder of trees.
You know,
that is the legal profession.
One of my first bosses used to say, he said, you know, we don't pay you a lot of money as an assistant prosecutor, but I mean the entertainment value alone, because it is entertaining in many instances, but it's also you're on the front seat of human nature. Very
you get an insight that a lot of people don't get.
Yeah, and you know what? You learn a lot about human nature when you do the work that it is we do for so long. So let's take a look at this package with the James Colley case, and we'll talk to you on the other end. Welcome back. That case is going to be very interesting, the Ambien defense, and I saw a lot of comments, people in our chat room, about the fact that Ambien can cause people to do some really strange things. I just don't think it's going to be enough on the involuntary intoxication, given what happened earlier that day with regard to the domestic violence issues.
Oh, Ambien can without a doubt cause some really strange things. My friend AJ once got up in the middle of the night and peed everywhere on Ambien. Probably shouldn't be saying that on air. But
okay.
Look,
your friend's going to be very, very happy. We're going to segment that clip. But listen, folks, gavel to gavel, we hear that there's a witness, the grandmother's on the stand in the Georgia versus Leon Williams. Riveting. Let's listen to her. All right, we're taking a little short break here, real quick. Ken, Leon Williams' case, this is his mom testifying. Obviously, the prosecutor wants to get information out. Either her memory isn't good or she's not able to remember. So now the prosecutor's in that place where she's kind of impeaching, for lack of a better expression, by showing her previous statements.
Yeah, look, she's going to show that this woman might have, you know, some motive to fabricate or misremember things, given the fact that it is her son that's on trial. And, you know, even though it was a 10-year-old boy that was murdered, the 10-year-old boy was not actually, he was a foster child, was not of blood relation to her, but, you know, her son is related to her, and she might be a little bit biased in her testimony.
Yeah, and she could also just be a witness who's just having difficulty remembering specifically. It's a lot of stress. She seems like a very decent lady. She's obviously in a difficult situation. Let's go back to court. Welcome back. We only have a very one-question opportunity to talk to Ken Belkin. trial analyst at the Law and Crime Network. And so I promised not to bring up his friend AJ, who was on Ambien and peeing that he brought up before, and I will not ask him a question about that, but I will ask.
I'm going to catch a lot of hell for that, I think.
What I will ask is, what do you think of Mom's testimony and the prosecutor's kind of a little bit wrestling with her?
I mean, I think this is incredibly difficult for her. You know, on one hand, her 10-year-old foster grandchild is dead. On the other hand, he's dead at the hands of her own son. You know, this is a terrible predicament for her to be in.
You know, that's a great point. We often don't talk about the tragedies that the innocent family members going through, both with her son and her grandson. Very difficult. Ken Belkin, thank you so much for your great and excellent legal analysis. As always, let's get back into that courtroom, and I'll be back with our viewers on the other end of this testimony.